Okay, it's 12 o'clock, so we'll go ahead and get started as I continue to let those entering in. Welcome to our weekly Lunch and Learn series, number 2 of the month. Today we're talking about domestic violence and intimate partner stalking. Just a few housekeeping things before I introduce our panelists, or I guess presenters today. First of all, please make sure you're muted. Otherwise, if I hear you making noise, I'll go ahead and mute you myself. Secondly, if you have any questions, you can go ahead and throw those in the chat. Our presenters have said that they prefer questions ongoing, so I'll be moderating that and can interrupt them as needed. And then lastly, I will put the PDF of the slides into the chat in just a second here. And when we finish up, I'll also throw a link for an evaluation in there. So without further ado, then I'd like to turn it over to our presenters to introduce themselves, and then we'll get started.
Good afternoon. I'm Becky Winstead. I'm Vice President of Domestic Violence Services with Remedies.
My name is Alex Ronning. I am the supervising attorney of the Domestic Violence Unit at the Winnebago County State's Attorney's Office.
Welcome.
Okay. All right, so we'll get started. So in our presentation today, it's focused on domestic violence and stalking. So we'll be talking specifically about intimate partner stalking. I'll go over some dynamics and stalking behaviors, and we'll talk about safety planning and strategies to offer survivors. And Alex will talk about stalking laws and prosecuting stalking. So this is a behavioral definition, not necessarily legal definition, but stalking is a pattern of behavior directed at a specific person that would cause a reasonable person to fear for the person's safety or the safety of others or suffer emotional distress. I want to point out that it's a pattern, so usually 2 or more behaviors. Sometimes that's referred to in statutes and definitions as a course of conduct. And we'll talk more about that fear component in a little bit. So how prevalent or common is stalking? 1 in 3 women and 1 in 6 men experience stalking at some point in their lifetime, and approximately 13.5 million people are stalked annually. You know, sometimes we think about, or whether it's advertised or promoted, maybe in the media, or situations of people being stalked by strangers or acquaintances, or celebrities being stalked by fans. But most of the time, the victim who is being stalked knows that person who is stalking them. And 40% of stalking victims are stalked by a current or former intimate partner. I also want to point out that stalking can happen before, during, or after the relationship. Sometimes we think about stalking after the relationship has ended and that stalker, that person is trying to get them back, but it can and does happen during the course of the relationship as well. So, on average, intimate partner stalkers, or people who stalk current or former dating partners or current former intimate partners, are more dangerous than people who stalk acquaintances or strangers. And, let's think about this. What's different about these situations? If you're in a relationship with someone, you learn a lot about them, about their life, access to a lot of information, and that creates additional opportunities and points of contact, opportunities to engage, basically. So, the person who's stalking might know details, most likely knows who their friends and family members are, might know where they live, which might also be the places where that survivor might go to for safety. They probably know where they work, where they go to school, what their schedules are, know information about their interests, their hobbies, their fears, may have personal information that they could use against them for threats or blackmail or intimidation. So all of these things can make it, unfortunately, create more opportunity for intimate partners to stalk that, or different ways that they can use those tactics. So stalkers generally use a variety of tactics, but intimate partner stalkers tend to use a wider range of those behaviors, or wider range of tactics. They're more likely to approach and contact the survivor more frequently. There's more risk of assault of that survivor and or third parties that may be associated with them. More likely to follow through on threats and to escalate the frequency, intensity of the stalker. Overall, they're, like I said, more dangerous in terms of stalking and also are more likely to use or threaten to use a weapon. So stalking often co-occurs with forms of intimate partner violence. It can be an indicator of other forms of violence. Abusive partners who stalk are more likely to verbally abuse, to commit sexual assault, and to physically injure their victims, in addition to using weapons, as I mentioned in the last screen. 74% of those stalked by former intimate partner report that there was coercive control during the relationship, and 31% of women who are stalked by intimate partners were also sexually assaulted by their partner. So again, risks of other violence and harm to those survivors. And when, in terms of physical violence, when physical abuse and stalking co-occur, the survivor is at a greater risk of homicide. So it's so important that we take reports of stalking seriously, because there is that increased risk of lethality. Stalking increases the risk of intimate partner homicide by 3 times. So again, we need to take that very seriously. So I'm sure you're all aware of common stalking behaviors, the repeated calls and texts, showing up when the survivor doesn't expect to see them, using technology to provide surveillance, to track their whereabouts, all sorts of things. We know that technology is used quite a bit in stalking. We could really spend the whole training talking about digital abuse and technology abuse and how those things, how different forms of technology are used. But that does come up quite a bit in a variety of forms. Okay, so other common stalking behaviors, sending unwanted gifts, leaving notes, flowers, messages, things that send a message that they're present, that they are watching, that they know where that survivor is. Identity theft, impersonating them, creating accounts on social media, or impersonating them in some other ways online. Spreading rumors, making threats in a variety of ways, could be in person or via technology, and violating any court orders that are ordering that person to not have contact with the survivor. So these are all behaviors and risks to that survivor. So I went through those quickly, but categories, stalking behavior can be put into these 4 categories, and they do overlap. I'll go over each of these separately, but keep in mind that one tactic or one stalking behavior could be a form of surveillance and also intimidation, or something as life invasion and also interference. But they can be grouped into these 4 categories. So surveillance is the type of stalking behavior that is most identified. Any of the following and watching behavior, trying to obtain information from friends, family, any third parties, or using those third parties to stalk that person. And often that other person doesn't know that they're involved in the stalking. It could be the lovely older neighbor who knows what's going on in the neighborhood, right? And this person who's stalking talks to her and says, I'm just so concerned about my ex-wife, Sarah, and I want to give her space, but, I think she's up to something, I think that, these people she's hanging around with, or this new guy she's dating is probably no good. And, I'm concerned about her safety and safety of the kids. Could you just give me a call? Can you let me know when you see, other truck or car around that you don't recognize? Can you let me know what's going on, right? So they might not even know that they're assisting, but sometimes third parties are involved. Using technology to track whereabouts. It could be using GPS, using cameras, a variety of technology, again, that is very prevalent in stalking. Couple examples that come to mind for me. A few years ago, I was helping out one day with our staff at our courthouse office. I was helping a woman with order of protection, and she was very concerned because her ex-boyfriend was using technology to stalk her. And she had gone to a family reunion or family gathering out of town shortly before then, and he was sending her screenshots like Google Maps and map images of where she was. And then you said, oh, I lost you for a second at that intersection, I've got you back, now you're here, right? And so that sent the message that he is ever present, that no matter where she goes, he will be able to find her, that he's always watching. And that would cause a reasonable person fear to know that they're always being watched. Another example that comes to mind for me in terms of technology is a woman that our staff were working with, and the woman walked out of her home for a job interview. And as she walked out the door, basically, soon after leaving her home, she got a text from her ex that said, "You're not going to wear that today, are you?" So again, the cameras, surveillance, just showing that they're watching all the time. So obviously that can be very scary. Also, situations where there's a lot of cameras in the home, so that might be an example of a current partner who is stalking and providing that constant surveillance. There's cameras all over in the home, and it's really difficult then for that survivor to take any steps to break free from that control and surveillance. Okay, so another category of stalking behavior is life invasion. So showing up in the survivor's life without their consent. So any of the unwanted contact, unwanted gifts, again, leaving notes on the car, flowers on the car, a gift at their job, a gift at home, letting them know they know where they're at, that they are present in their life. Whether that, without invitation from that survivor. Initiating contact through third parties, spreading rumors about the survivor, taking pictures, maybe the stalker's taking pictures of themselves in the survivor's home, in their car, at a business that they frequent, at some location that they like, again, to make that uninvited appearance and presence in their life. Disrupting their work, showing up repeatedly, or showing up and refusing to leave, making repeated calls to work. Many employers are not going to want someone to interfere with their business in that way. And so unfortunately, then sometimes survivors lose their job because they can't stop or control this person from showing up and disrupting the business that goes on. Okay. And then another category, intimidation. So using behaviors and actions to frighten the survivor. Keep in mind that any behavior, any action could be intimidating to that survivor based on the context of that relationship, of the abuse that they've experienced previously, the survivor's knowledge of what that abusive person is capable of. So on the outside, to someone else, it might seem like that behavior is not, or shouldn't be, or wouldn't be especially intimidating, but it has meaning to that individual survivor. So it's always important to keep that in mind. So intimidation could include implicit or explicit threats. Again, those could be in person or via any technology, damaging property, trespassing, threats by the stalker to harm, or threats to harm or actually harming themselves, including threats of suicide. Could include symbolic violence. So maybe sending a photo of a gun, sending an item that symbolizes something that they could do, a stuffed animal that looks like the survivor's dog and it's damaged, suggesting they could hurt their dog, or a doll that's burnt or damaged in some way to suggest that that's what they could do to the survivor. So again, things to intimidate, things to elicit fear for that survivor. Can include any of these and more, something that's specific to what would cause fear for that individual survivor. And then the last category, and again, these overlap, but it's interference. So interference can occur through sabotage or attack, anything to disrupt their life, impersonating, interfering with online accounts. So maybe creating a fake Facebook, or creating a Facebook account to appear as the survivor, making, and this would overlap with other categories as well, but presenting themselves as a survivor and then saying very negative things about, suggesting that they're participating in criminal activity or sleeping with a bunch of people, or your drug use, anything that damages that survivor's reputation as well, potentially causes harm to them. It could be an example of making that social media account and making it appear as if the survivor is trying to solicit sex and giving their personal contact information, making it very unsafe for that survivor, and potentially putting them at risk of sexual assault. So a variety of ways that people can interfere with their life. It includes damaging property. It includes physical assault or causing physical harm to the survivor or to their family members, their loved ones, and it can include restraint. So a variety of things that could also include interfering with the survivor's attempts to seek or maintain employment, to go to medical appointments, to seek services and other assistance, interfering with court dates, interfering with any action they're taking to try to separate from that abusive person who's stalking. So context is key. It's really important that we understand the context of the situation and the survivor's concerns. So again, stalking is a pattern where the person is causing a reasonable person to fear for their safety, the safety of others, or causing emotional distress. So keeping in mind that, again, that survivor has the knowledge and the experience, they are the expert in their lives. So it's so important that we believe survivors and turn to them and believe them regarding their experiences. You know, survivors' fear has been shown in research to be an excellent predictor of their level of danger. And so it's so important that we don't dismiss people's accounts of stalking and think, well, it's probably not that big deal, or maybe that isn't anything serious. If the survivor is fearful of their situation, then that is something that needs to be taken seriously. Because stalking behavior by themselves, without the context of that fear, aren't necessarily illegal activities, right? Leaving a note, sending mail, leaving flowers or sending flowers, those things by themselves are not crimes. But if that person, if the person who is stalking, their current or former partner, has said, next time I send you flowers, say goodbye to your mom because that's the day I'm going to kill you, right? That for sure is would cause a reasonable person fear. And so that context of what does that mean? What message is that person sending? What is that ongoing contact and surveillance and other disruptions and tactics? You know, what is the context in terms of the fear that that survivor may be experiencing? It's also important to keep in mind that people experience trauma differently. They express their feelings differently. They deal with the trauma differently. So we should not get too stuck in, you know, is this person presenting fear in a way that I think is a traditional way of expressing fear? Maybe this person doesn't present in a way that seems as fearful, but instead they're expressing their concerns in a way that they seem frustrated and agitated and angry at that person who is stalking them. That's understandable, and it's okay that they're expressing it that way. It's important that we don't dismiss those individuals and think, well, they're not acting afraid, so they're not fearful, and this isn't as serious of a situation. Stalking is very serious. It's a crime. It's something that we need to take seriously. And so please, you know, someone who doesn't express it in the same way does not mean that their situation of stalking is any less dangerous. We can help understand that context, though, by asking survivors to explain in a non-judgmental way. Can you help me understand what was scary for you in that situation? Can you explain these tactics, you know, and how was that scary for you? What are your safety concerns? And then I just want to point out that we should keep in mind in terms of underserved populations, each survivor, each person's situation is unique to them. And so also keep in mind that some stalking behaviors might compound other barriers or challenges that that person is experiencing and might make it more difficult for them to seek assistance, to reach out for help. It may cause other challenges in their life. Let's think about a situation where maybe the person who is stalking damages the mobility device of their ex-partner. That is creating a challenge for that person, that survivor's physical safety, not just in relation to direct physical threats that the stalker is making, but also to just accessibility in their day-to-day life, right? So those are things that we keep in mind in terms of any historically marginalized community. What other barriers might they be facing that can compound their difficulties, maybe their options or limited options that they maybe think they have, or their ability to access help and assistance and various remedies that might be available to them. Okay. So with stalking, and this is as domestic violence staff, we focus a lot on safety planning, and overall, I encourage all of you to believe survivors, to encourage survivors to think about their safety and to develop a safety plan. And it's important that it's really specific to that individual. Safety plans, in order to be helpful and effective, are going to be survivor-centered. It's not a cookie cutter approach. And survivors will know best. They're the expert in their lives. They know best what they've experienced, what the threats have been, what the stalking behavior has been, and what that means to them. So encourage survivors to create safety plans. Domestic violence advocates have a lot of experience with safety planning and can help with that. So you're going to encourage survivors to reach out to local resources for help with that. But these are some tips that you could recommend in terms of safety planning. So changing routines, installing security cameras, changing locks, if they have a good support system, to keep those individuals informed of what their concerns are, who should not be on their property or, at their place of employment. Encourage them to file for an order of protection, to report instances of stalking to law enforcement. When possible, we encourage people to engage with the offender, because engagement can sometimes encourage the stalker to continue behavior, but that's complicated with domestic violence, and it's not always realistic for someone to completely disengage with a current or former intimate partner, especially if they have children together. There could be challenges with that. So as with any other steps of the safety plan, it's just important that the survivor is the one that makes that decision about what's best for them at what time, how much can they disengage. But of course, we want survivors to do what they think is safest for them. And then documenting stalking behaviors. It's going to be difficult later on if they're trying to gather evidence and information to have all those details available to remember everything. So we encourage people to document stalking behaviors. It could be on a log like this, could be notes on a phone or an app, but it's important to keep track of those incidents, time, date, other details, witnesses, was it reported to law enforcement? This can also, having it in writing, having it in one place, can also help survivors notice if those tactics are increasing in frequency or severity, and then that may lead them to adjusting, modifying their safety plan. What are their new concerns? What are their current risks? So they can adjust and plan accordingly. And then I mentioned technology is used quite a bit. 80% of stalking victims report being stalked by or via technology, and that could be anything from texting, cell phone, GPS, cameras, a variety of devices. If that person who has stalked, if their current or former partner has access to the survivor's phone, computer, any devices, it's important that the survivor tries to find safer devices to use to access help, to communicate about any plans that they have. So when possible, to get a different device or use a safer device. Changing passwords, security questions for their accounts. Again, cameras, security systems, any of those things that might help. Later on in the slides, I mentioned NNEDV, that's a National Network to End Domestic Violence. They have a safety net program that focuses and provides a lot of information about technology safety planning, tips for survivors, advocates. So I encourage you to look there for more information about that, because there is a lot available. And then, again, overall, I encourage, when working with a survivor, when talking with someone, if someone discloses stalking to you, I encourage you to believe them. First and foremost, just believe them, let them know that the stalking is not their fault. But beyond that, you can encourage these tips, you can recommend these things, but encourage survivors to trust their instincts. Their fears are justified. Again, we don't want to minimize it. Stalking is a crime, it is serious, and so we should take it seriously. Again, I encourage people to document, to report the stalking behavior, create safety plans. I say plans because, again, they're ever evolving and may need to be adjusted and changed based on current circumstances and needs. And encourage individuals to seek help from domestic violence advocates or others who could assist with the safety planning. And to utilize community resources, and that includes reporting to law enforcement, filing order of protection, court involvement, anything else that could assist them. Okay, so now I'll pass it on to Alex to talk about prosecuting stalking cases.
Hello again. My name is Alex Ronning. I am the supervisor of the domestic violence unit at the Winnebago County State's Attorney's Office. We have slides here, and I'm going to go through the statutory authority for stalking as charged criminally in our courts, other related offenses that are often part and parcel to those cases. I put together an example case, and then I prepared some talking points on the benefits and some of the challenges in prosecuting and charging those stalking cases. And then at the end, to the extent I'm qualified to discuss it, there's stalking in the context of the Pretrial Fairness Act, which is very fresh and very new to us all, including myself. Before I get into that, I just kind of wanted to give some background as to my arrival in this particular topic in the context of prosecution. I was a younger prosecutor in the domestic violence unit for a period of time, 2018, 2019. And I really enjoyed prosecuting domestic violence cases. I found it very fulfilling and engaging because each case mattered. Each case, it didn't seem, unlike other courtrooms where you have cases that you almost feel like a chaperone of some preordained result, and that there's, a very balanced look. You have to temper multiple policy considerations. With domestic, I was free to be passionate about these cases. And the reason I bring that up is because eventually I left the domestic violence courtroom. I went to a felony courtroom, a general felony courtroom, and quickly found it felt like the volume was just turned down on my job. And some of those cases I cared about more than others. I certainly gave them all a good effort, but what kept me through that period of time when I was away from the domestic violence courtroom before I came back was certain cases that kind of slipped through the cracks and came into our courtroom that probably should have been in courtroom C in front of the domestic violence judge at the time. One of those cases was a stalking case. And prior to going to that courtroom, I hadn't really considered stalking. I was used to all the action, boom, pow, strangle, like all the action of a domestic violence case, and was very experienced in prosecuting those. But then I got this case. I'm not sure if I should say the defendant's name or not, but he it seemed like a full-time job stalking all his ex-girlfriends. And it was amazing to me how many ex-girlfriends he was able to accumulate, people willing to date him. But he had like a web. I felt like it was a beautiful mind in my office because I had the string connecting all these people, everybody's mom, sister, brother, grandma. He was driving past all their houses and leaving notes, slashing tires, showing up at intramural baseball games. I still remember the kid. And ultimately, he had no criminal history because a lot of times stalkers haven't revealed themselves to the criminal justice system yet, and we kind of happen upon them. Ultimately, there was a I want to say it was like a 37 person long no contact order on as part of a probation disposition in that case. And I bring that up to say, because that was like, I remember going to the Family Peace Center, meeting with detectives and discussing all these reports that people were filing about this really petty but terrifying behavior that this guy was committing. And it was natural to me that my attachment and engagement with that case came from the same place that my domestic violence passion came from. And it wouldn't necessarily be apparent on the surface. So it's a long way of saying that stalking is very much in with intimate partners, obviously, very much a domestic violence crime. Domestic violence sort of relies on putting the victim in a locked room and disallowing them access to the outside world oftentimes. And stalking is maybe the purest example of that, which is why I find it so offensive. And considering that I've said it before, that it's the kind of thing that as a prosecutor, like when I was in the courtroom before, we never charged it. I didn't get that case. It was, I'm not sure I had a stalking case in the 2.5 years I was in domestic violence before my current tenure. But then the more you see it, the more you see it. And I can think back on my life too, that, I thought I had no domestic violence real exposure before becoming a prosecutor. I didn't know anybody that was the victim of domestic violence that I was aware of. I had no exposure to it, but I found it very offensive on a very visceral level. And I think it's because now I look back, I knew plenty of people that were stalked, and in college and high school, as an adult. I was the person. I was aware of people and other people I knew had people in their lives that were willing to do the thing that the person with nothing left to lose will do. It's kind of like a brinksmanship sort of behavior that stalkers exhibit. And as soon as I started to see it in my professional life, I realized how often I had seen it before. So I'm going to get into the actual reason for the presentation, but I just wanted to start by explaining the connection between stalking and domestic violence, because I think at the heart of it, it's very similar, even though the behavior is often very different or seems very different. So one last thing personal about me, I'm awful with technology. So I have my flip phone here for anybody who can see it. So that's why, not because I'm overbearing or oppressive, I'm asking Becky to advance the slides for me. So Becky, next slide, please. Okay, so stalking, traditionally defined by or classically defined by the state statute, exists under 720 ILCS 5/12-7.3. And we're going to be looking at two slides containing the different versions of stalking. The one we charge most often is straight away under A1. So you're looking on the slide, if you're looking at the PowerPoint, the first bullet point is one of the ways stalking can be charged. A person commits stalking when he or she knowingly engages in a course of conduct directed at a specific person, and he or she knows or should know that that course of conduct would cause a reasonable person to fear for his or her safety, or the safety of a third person, or suffer other emotional distress. We can charge it either A1 or A2, so there's a choice between fear for safety and emotional distress. It's sort of a matter of personal preference to the prosecutor, ultimately what they want to be arguing to a jury, what they feel that the evidence proves or most cleanly shows. And we'll get to what a course of conduct is in a moment. That's the other main part of the definition. But I often charge A1, that the conduct would cause a reasonable person to fear for their safety, because it very clearly often would. There are other formulations that are just kind of variations on a theme. We have A-3, which incorporates, so what we'll see in a moment is that course of conduct is multiple instances of non-consensual contact, whether that be monitoring somebody, surveilling them, following them, showing up unannounced, contacting them, making threats. And those have to be there's case law on what the threats can be, but essentially what's been determined, true threats. And these other formulations you'll see in A3 is variations on a theme that explicitly incorporates the threat element. But the spirit of it's the same. On 2 separate occasions, follows another person or places that person under surveillance, and at any time transmits a threat of immediate or future bodily harm, or places that person in apprehension of the same. Let's go to Becky. Next slide, please. A5 and A7 are similar. I would note with A5, so it's a good way to think of it is 2 or more instances of following non-consensual contact, whether that involves threats or not, and creeping on a person on more than one occasion. And that could all be on the same day, but it needs to span a period of time and cross across multiple mediums. So like a text thread showing up at the house, following that person to work, that would be a course of conduct all on a single day. A5 is the exception where a person's been convicted of stalking before against a particular person, and then on one occasion follows that person, places them under surveillance, or transmits a threat of future bodily harm or any of these other things. That's one kind of a unique way to charge stalking, is if we have a conviction on him already against this particular victim and he continues to do it, we don't need to show more than 2 or more instances. An additional instance drafting off the prior course of conduct is sufficient to prove a subsequent charge of stalking. And as I indicated, the definition for course of conduct is 2 or more acts, including but not limited to. So it's kind of like an open definition, but including but not limited to acts in which a defendant directly, indirectly, or through third parties by any action, method, device, or means follows, monitors, observes, surveils, threatens, or communicates to or about a person, engages in non-consensual contact or the like. And it may include electronic communications. We've started, now that we see stalking more than we have, I've seen all kinds of behavior that meet the definition, that fall under various courses of conduct. A lot of the things that Becky was saying resonated with me. I was writing down some of them. The symbolic violence, it's a great way of saying something I often see. So in a minute, I'm going to be giving a hypothetical example of a stalking scenario, and none of the parts of that example are made up. They're all bits and pieces. It took me 30 seconds to write down because they're bits and pieces of all cases I've had. And one of the things is taking a picture. I had a case where a defendant took a picture of a gun on his dashboard in his car and then was in his car outside her house. So that is certainly symbolic violence. And not only, so on its face, that's scary. But it puts the victim in that locked room because it relies upon her understanding from their prior relationship that that's the inside of his car. And he knows that in sending that picture. At the heart of all these cases is an attempt to isolate the victim, whether by putting the victim in a place of loneliness or isolation, or removing them, as Becky said, from their friends and family or employment. I have so many cases where a stalking defendant will contact incessantly a place of employment, and to the point where, thankfully, I haven't heard of anybody getting fired because of a stalker's behavior, but that's certainly the risk, and that's certainly the fear that it places in the heart of the victim. And I'm sure there's an inclination out of embarrassment to want to leave the job because oftentimes it involves the airing of dirty laundry and the disruption of the workplace, which is really isolating in a different way to the victim. I had a case, actually the case that I was referring to earlier with the 37 no contact order. where a victim was working at a restaurant and the defendant came in just to order a sandwich. And the way he did that it was no different than any other patron, but the way he did that, but the mere fact of after her getting the OP, after him saying he was going to kill her grandmother and lighting fireworks on her lawn and showing up at the baseball game, walking into the fast food place, staring at her, ordering a sandwich, paying for it, and then leaving without the sandwich, is extremely threatening and offensive, but completely invisible to anybody else who's there. It's, to me, a level of cowardly even below some of the domestic violence cases that we have. And I don't mean to put any over any other, but it stays with the victim. And it's gaslighting. It's kind of an overused cliche at this point, but it really is. It's just awful. So next slide, please. Aggravated stalking is another kind of cherry on top so you can think of it as, to get to aggravated stalking, you need to have stalking. And aggravated stalking is all the things we previously mentioned, and causing bodily harm to the victim, confining or restraining the victim, or most commonly in violation of an order of protection. And I'd like to think that in Winnebago County, that our intent and practice of charging stalking more has led to individuals being more comfortable getting orders of protection and seeking the protection of OPs, because it seems like we're seeing now more and more. Whereas in the past, when we started charging stalking, there were very few aggravated stalking cases, and now it seems like we're getting most of the time when I'm getting a stalking charge, it's an aggravated stalking, which to me, I would hope is some recognition from the community and the victims that pass through the court system that OPs can be of benefit, and that creating a paper trail, which we'll discuss a little bit later, is important to these kinds of charges. The benefit of aggravated stalking is that it's a class above what stalking would be. So for a first offense, regular stalking is a class 4 felony. For a second offense, regular stalking is a class 3 felony, and then just +1 for aggravated stalking. So a first offense of aggravated stalking is class 3 felony, and a second offense of aggravated stalking is a class 2 felony. And class 2 felonies are important gets from a prosecutorial standpoint for a variety of other reasons. So there is a kind of a stepwise approach to stalking under the statute. We can go to the next slide. Yeah. So cyber stalking is something that we don't often charge. As I noted in some of the prior slides, that electronic communication can comprise part of the basis for a regular stalking charge. And cyber stalking seems to limit what otherwise stalking charge would be purely to electronic communication, or that there's a following the person's online presence. That requires, it's usually, we rarely see a case that requires charging cyber stalking. Most of the time, it is a better fit under stalking. And so cyber stalking is sort of, I view it as an asterisk or something on the side. And if there was ever a case that were to come across my desk as involving pure online activity, maybe somebody assuming a social media identity, or incessant communications purely through electronic means, we would use a cyber stalking charge. But our familiarity and the simplicity of stalking under A1, as I have it on this slide, usually wins out versus charging cyber stalking. So we usually go with that, but that is a charge that's available to us as cyber stalking. We can go to the next slide. A lot of this I already explained off the cuff at the beginning, but and I'm going to get into this a little bit when we talk about the benefits and the challenges, but unlike domestic batteries, for example, stalking is not always understood to be stalking, either by law enforcement, by prosecutors, or even by victims of stalking. That it requires sort of a seeing the forest through the trees. That, as we discussed, like any particular incident, whether it be going to the baseball game, going to the restaurant and ordering a sandwich, or sending the threatening text message, each one of those incidents hopefully is being reported to police. When it's reported to police, they're often not seeing the full context and only seeing that particular incident. And then the way, in our experience, the way stalking charges have come to be is either through like a task force involvement, where there's multiple people sitting around a table talking about a particular defendant and identifying patterns. But more often than that, even, is just, as a prosecutor, I'm going to court with my cases and I'm saying, geez, I got 5 cases for this defendant, and maybe I got 1 felony and then a disorderly conduct, a violation of bail bond, that it becomes more and more obvious that there's a pattern occurring. And it would be very easy as the prosecutor to just keep going with the charges that we have. But to get to stalking, then we have to reassess everything in light of the entire context and the entire pattern. And that becomes that's easier. It becomes more possible the more thorough the domestic violence prosecutor is being with this prosecution anyways. So if I have an electronic or a telephone harassment case where there's a singular incident of an ex-boyfriend making threats on the phone to his ex-girlfriend, and then I'm going through the case and I'm reviewing, let's say that's led her to get an OP, and then I look at the OP petition and I see this long factual summary that goes back 1.5 years of him bothering her, stuff that she never thought she should or could report to police. And I'm seeing that he's showing up at her house, he's calling work, he's buying the sandwich. That would all be a basis to charge stalking. That would also be something we would look at. So we would traditionally look at that as a part of a propensity motion, which is it was basically, in the domestic violence context, saying this singular incident of, in this case, telephone harassment or domestic battery or violation of order of protection is part of a pattern, judge, and we want to bring in all these other things to show that this was knowing and intentional, and that this defendant has a propensity to commit acts of domestic violence, like all these other things that are not charged. If we're looking at all the information available to us to file that motion, and looking at what other cases he has charged, or even speaking with the victim directly, stalking becomes more obvious. So the more a domestic violence prosecutor is thinking through all phases of the case and in advance of trial, and thinking, how do I establish the context for this isolated incident, the prosecutor learns that it's not an isolated incident. And that's when stalking reveals itself, oftentimes. So we can go to the next slide. I've been referring to other charges, and I put this slide together to kind of explain sometimes a dilemma that prosecutors face, because as you see, and I'm basing this off first offenses, so stalking class 4, cyber stalking class 4, aggravated stalking class 3. A lot of times the stalking behavior is comprised of threats over the phone or text message, unlawfully restraining somebody, criminal trespass to residence, violating an order of protection when there's been a prior conviction, or even a domestic battery. Like any criminal charge, has to be proven beyond a reasonable doubt, and stalking is a pattern of behavior. So you have to prove the whole thing beyond a reasonable doubt to get that class 4 felony conviction. Meanwhile, all the component parts, phone harassment, electronic harassment, whatever the case may be, are singular incidents that can be proven beyond a reasonable doubt that would also be a class 4 felony conviction. So on the surface, it may seem not worth our while. 10 minutes. I was so worried that I was going to have all this extra time. I should have known better. So the dilemma is why charge stalking? So let's go to the next slide. We'll zoom through this. This is an example fact pattern. Jane breaks up with Jimmy. Jimmy can't let it go. Jane dates Joey. On Tuesday, Joey stays the night at Jane's house. Jane wakes up at 3 a.m. to 17 text messages from Jimmy demanding to know whose car is in her driveway. She texts him back to leave them alone, and he responds with a picture of a gun laying on the dashboard in his car. Symbolic violence. Wednesday afternoon, Jane gets an OP against Jimmy. She continues to receive texts from Jimmy and tells him about the OP. He texts her that nothing will stop him. That's important because not only is that a threat that drafts off the prior threat of the gun in the car, it's acknowledging actual notice of the OP, which would obviate the need for service. So we can charge VOP based on that response. On Thursday, Jimmy shows up at Jersey Mike's when Jane is working. He stands in line calmly, looks her in the eye, orders a sandwich, and then leaves without getting it. Jimmy has a prior conviction for purposes of this example for domestic battery. Again, none of this was from my imagination. This is all cases that were immediately out of my memory from stuff I've dealt with in cases. So the next slide, this was going to be audience participation, but we'll just zoom through this. This is how we would charge it as a stalking case. And I kind of did a graphic to show how we think about it as prosecutors, that we have to show, if you remember the definition, that it's 2 or more incidents of this long list of, this open list of behaviors. I could charge, so Tuesday, when she wakes up at 3 a.m. to 17 text messages asking about the car in the driveway with a picture of the gun in his car, I would charge 1 count of stalking. That's a singular day, but that's non-consensual contact. She broke up with him. He's texting her 17 times in the middle of the night. That's surveillance. He's outside her house. That's how he knows the car is in her driveway. And then picture of a gun, that's communicating a threat. So I would say I would take a shot at charging stalking from that day alone. I would also charge at the same time stalking from Tuesday into Wednesday, where she texts him that, where he's she receives it. She continues to receive texts from Jimmy prior to him learning about the OP. That's just an additional way of charging it. If there was any dispute about whether Tuesday was a course of conduct, I would include Wednesday as a secondary count just to shore that up. And then I would isolate from Wednesday to Thursday because the whole thing needs to be a knowing violation of an OP for it to be aggravated stalking. So everything from the point at which she told him I got an OP and he said nothing will stop, that into Thursday would be aggravated stalking. Now, it's important to note that this would all be 1 case, 1 trial. If we were to charge it traditionally, like the stalking statute didn't exist, we would go to the next slide. It would look like this. We would be charging 3 different cases of the electronic harassment of the 17 text messages. We could probably charge that 2 ways, but electronic harassment from Tuesday, violation of order of protection and electronic harassment from Wednesday, and violation of the order of protection when he shows up at Jersey Mike's on Thursday. These would all be the same classes of offense, essentially, as what we charged in that singular stalking case, but we would have 3 bites at the apple. We would be able to proceed to trial on felony 1, felony 2, felony 3 separately, but it would require filing a lot of motions and having a lot of litigation around, like if we were to take CF1 to trial, I would have to file a lot of motions saying, Judge, I also want to talk about Wednesday. I also want to talk about Thursday. You need to allow me to be able to bring up that this just wasn't 17 random text messages in the middle of the night. This is electronic harassment, and he continues to do it. It was not a mistake. That would require a lot of work. So there's kind of the cost and a benefit to charging these cases separately, and then or putting them all together under stalking. Stalking, I prefer to do the stalking route for a number of reasons, but among them is that it simplifies the proofs at trial. If charging it as stalking, it's going to be 1 single trial, but I'm not going to have to debate with the defense attorney in front of the judge that these other days should be part of the trial or not. where it's all going to be part of what I'm proving because I have to prove that course of conduct. So with the added burden that the stalking statute, the added burden that gives us also gives us an added opportunity to establish a further context. So we go to the next slide. Okay, we got 5 minutes. So I touched upon that the component parts of stalking are often just as severe as the stalking charge itself. Stalking cases are oftentimes difficult because a lot of the strategies we use to prosecute cases without victims are more difficult in a stalking context. Suffice it to say that in like a normal domestic battery, aggravated domestic battery, we can potentially pursue charges against a defendant without the testimony of a victim when the situation is hot, where there's an emergency and police are responding to an emergency, and that all the statements that are being made are excited utterances, that there are exceptions to hearsay, or that there's statements to a medical provider pursuant to treatment of injuries. We usually don't have that with stalking. And even if we do, we would need to have it on all the different parts. So Tuesday, Wednesday, and Thursday, we would have to have excited utterances or other hearsay exceptions to prove all that course of conduct over that time. And usually we're seeing things in reverse. So it's only after I'm seeing the LP or only after we're speaking to victims that we're identifying these patterns, and the short period of time where we can get admissible statements out of discovery has long since passed. So these are cases that often require the cooperation of victims. And as we touched upon, stalking patterns are difficult to identify because cases are charged individually. So it takes a holistic view and sitting down with multiple files and seeing, is this non-consensual contact? Does it fit the patterns of stalking? And bureaucratically, once those cases are charged, we have case numbers assigned to police report numbers that exist in our system and are all tied into full court and all this stuff. We have to often undo all that, make a new case, dismiss these other cases, make sure they're not counted as dismissals, and put them all together in a bureaucratic way that with the high volume that we have is sometimes difficult. So those are the challenges, and I just want to get to the benefits because there are many benefits before we close up today. Like I said, strategically, it brings everything under one umbrella, that we don't have to fight tooth and nail, even if we had all the time in the world, even if hard work was no issue, and that we could file all the motions we want to file on every case. It still presents a risk that the judge will deny those motions. So when we prosecute stalking, we are removing any doubt that the pattern of the full extent of the pattern behavior charged will be brought in front of a jury, and that's often very powerful. And then once we get the conviction for stalking, it can enhance future stalking charges and be used with the stamp of the conviction on a stalking, that there's no longer any doubt that entire course of conduct was committed. So it's, in my view, a very important conviction for later purposes, and that if I want to use that as propensity material to a later domestic battery or aggravated domestic battery, or if he's later, as what happened with the Kyle Kirschbaum is his name, as what happened with the guy at a courtroom 478 that I had between tenure in domestic violence. He picked up another case later on, and that entire stalking conviction, all 37 of those people that he abused, was supported by conviction and used in aggravation to send him to prison. So the stalking conviction is valuable because it's hard. When you get it, it's valuable. It also, not least of which, the stalking conviction allows for the entry of a lifetime order of protection. It's a very satisfying feeling for both us and petitioners to write that the end date on an order of protection is the year 2199 or whatever we have to do to ensure that it's a lifetime order of protection, that there's no more dealing and looking at him in court and playing this game of, did it happen? Are you justified in seeking an order of protection? There's a lot of solace that I see on the faces of victims when their order of protection is put to bed, and it's going to exist, and it's never not going to exist. And I think that just the word stalking matters. So that'll be the last thing I say. It's 1 o'clock. All these cases, domestic violence, stalking cases, are victims being isolated in some form by the actions of their abusers. And seeking the conviction, just having it said on the record that something happened, is very important. I think, in my experience, it seems very important to victims. And stalking is certainly the case with stalking. That to all that isolation that the behavior causes, is when that's recognized by the conviction for what it was, I see a lot of healing happening with our victims then, and I'm very happy for that. And like certain other cases, like I would put it on par with like animal torture or like aggravated cruelty to animals. When you as a prosecutor see a stalker or some of those other kind of convictions on a criminal history, it correctly identifies the person uniquely as a certain kind of threat. So I think I'm out of time, but I got through a lot of what I wanted to say.
No,
Does
thanks.
anybody- Yeah.
No, I was just going to open it up for questions. There's a little slide about pretrial fairness. So if anybody's interested in that, you can stay on and we'll muddle through it together. But any questions for Alex or Becky before we close it up? And you can unmute or throw them in the chat. Otherwise, I did put the evaluation. I'll send that out through email as well. And then, as I mentioned, this is number 2 of 5. So next week we have our 3rd in the series. We're going to talk about domestic violence and strangulation. We'll be joined by Kim Wolgast, who's been certified as kind of an expert witness, master's course level in strangulation, and she'll talk with us about domestic violence and strangulation. So as people are leaving, Alex, do you want to review pretrial fairness or just see if there's questions for people? I don't know. Yeah. They can reach out.
Yeah,
I feel better.
so, I mean, the slide kind of says the extent of my understanding. We're all kind of muddling through it at the moment, that there's particular standards. So I will say this, there are particular standards for detaining somebody under a dangerousness standard. There is a particular section about stalking in particular. I've said particular like 4 times, but stalking is has its own place in the statute. And it requires a finding that denial of release is necessary to prevent fulfillment of the threat upon which the charge is based. It's frustrating because there are ways to charge stalking that don't involve explicit threats. So the concern, just sort of prospectively, the concern that we have is that if somebody's following, if I have a case where a defendant is doing everything but threatening the victim, following her to work, calling her work, sitting outside her house, leaving flowers, sending a million text messages, and it's the absent a threat, otherwise an awful stalking case. There's no this basis to detain that person seems difficult to attain, and we have to seek it under this section because it's particular to stalking. So I wonder if there'll be case law around that going forward. And with any new statute, we're gonna have to massage out the details through appeals and everything. So we're kind of waiting to see what's going to be made of that.
Thanks, Alex. All right. Well, again, thank you. We'll close up officially for the afternoon. I appreciate everybody's attendance, and Alex and Becky, appreciate your expertise around this. I really appreciated kind of having both perspectives, the survivor perspective, advocacy perspective, but then also the prosecution strategy. I thought that was really interesting. So thank you, everybody. We hope to see you next week. Don't forget to fill out your evaluation and have a great rest of your day.